The Supreme Court decision to keep Donald Trump on state ballots goes down in history as unanimous. But there is a split, 5-4, over whether the court should have brought Congress into the ruling. Conservative Justice Amy Coney Barrett, siding with the 3 liberal justices against her conservative colleagues, saying they went too far by ruling the only way for the 14th Amendment's insurrection ban to be enforced is if Congress passes legislation first. I want to bring in Temadayo Aganga-Williams, former senior investigative counsel for the House Select Committee to investigate January 6th. Also with us, President and CEO of the National Constitution Center, Jeffrey Rosen. He is author of a new book, The Pursuit of Happiness: How Classical Writers on Virtue Inspired the Lives of the Founders and Defined America. Jeffrey, help us understand the importance of this split.
The split is significant. And the most important thing is that the liberals feel that the court went so far that they quoted Bush v. Gore and the majority's decision in Dobbs, the abortion case. They quoted Justice Breyer as saying what was done should have been left undone. They quoted Dobbs as saying if it's not necessary to decide, it's necessary not to decide. And they said that, yes, it's right to kick him off the ballot for states, but for the court to go beyond that and say that no federal court could ever decide that he's guilty of insurrection violates the original understanding and text of the Constitution. And that's why it's so significant that Justice Barrett joined. She is an originalist and a textualist, and she feels that her conservative colleagues were violating those principles in not being restrained.
Temadayo, at risk of overanalyzing this, do we look at this split as saying, you know what, the justices can look at cases dispassionately. They can come to a unanimous decision on something that is politically charged. They can also disagree. And in an era where we think the left is so far from the right and the right is so far from the left, you can actually have a conservative justice who sides with progressives.
Yeah, I think if you're looking just at the narrow point of Judge Barrett, but I think the more complicated is how do you look at the 5 men and where they came down upon this. I think it is encouraging that you had the 4 women basically saying show restraint here, and that's not what the court has done. The court in one way showed some restraint by not commenting on the issue that's most important, which is, to me, whether or not the former president was in fact an oath-breaking insurrectionist, which our committee, I think, demonstrated to the American people. But then the court decided to go really far and more aggressive and basically limiting the potential relief that anyone can get to get President Trump or anyone else off a ballot, and saying only Congress can do this, which means, for example, if Jack Smith had charged the president with seditious conspiracy and he was convicted, that wouldn't be enough. If a federal judge had held a trial or a hearing and found the same things the Colorado Supreme Court did, that wouldn't be enough. It's only Congress, and frankly, in the political climate we have, that effectively means the court has said that the former president will be on the ballot no matter what he in fact did.
So let me ask you then, because you are somebody who have pored over so many details of what happened on January 6th. You yourself have spoken to dozens of witnesses, right, who were involved with the January 6th committee. And I'm wondering, when you heard this decision today, wasn't a surprise, right? We expected this. But if you think that there are farther reaching implications, then what a lot of people will look at and just say, you know what, these ballots, Donald Trump is going to be on them. OK, let's move on with the election.
I think we shouldn't be doing that, right? I think the core, this opinion does not get to the substance and the core and what I think really matters to voters and what should matter to those who care about democracy, which is whether there was an attack, a rebellion led by a former president against the Constitution, all in violation of his oath. The evidence unquestionably supports that. That's exactly what he did. And it is telling that you had a court here of the 5 male justices who were willing to be aggressive on his behalf, but that what they couldn't do is to get to that substance of that question. You see nowhere in the opinion where they defend him. And frankly, in his underlying briefing, the former president says he did not engage in insurrection. The court doesn't get to that question because it couldn't, because the only answer that the evidence supports is that he, in fact, did engage in insurrection.